Good afternoon. This is Mindy Giftis, one of the leaders of Husch Blackwell's Data Privacy, Security, and Breach Response team. Welcome to Why You Need a Data Breach Plan webinar. Today we will discuss the key components of data breaches and what companies can do to prepare for them before they occur. Before we begin, I would like to cover a few housekeeping items. At the bottom of your console, there are several tools that you can use during the presentation. First, there's a box you can use to submit questions to us. There's also a Q&A icon. We appreciate audience participation and encourage you to submit any questions you have. We will try to answer all questions during the webcast, but if a fuller answer is needed or we run out of time, we will answer it after the webinar via email. If you have any technical difficulties, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and a checklist of the steps that should be taken in the first 24 hours after discovering a data breach are available in the resource list icon that looks like a folder at the bottom of the screen. This program has been approved for CLE credit in Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. Wisconsin approval is pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with the certificate of attendance. With all of that covered, let's get started. Joining me today are Mark Greider and Jeff Jensen. Mark is a member of the Data Privacy, Security, and Breach Response team. He is an experienced trial lawyer and investigator who has been involved with a number of high-profile matters in Washington, D.C. and throughout the country. Mark advises clients in the areas of white-collar criminal investigations, anti-corruption policies, whistleblower complaints, regulatory enforcement actions, healthcare, and government contracting. Jeff is also a member of our Data Privacy, Security, and Breach Response team. He advises clients on complex federal litigation matters, internal compliance investigations and reviews, data breach response, and emergency response to government investigations. Jeff has secured favorable results for clients in a wide range of criminal and civil matters. With that, I'll turn the floor over to you, Mark.
Thank you, Mindy. As we at Husch Blackwell work to help companies, executives, and entrepreneurs, and even startups like yourself on the call today, our goal is to help people like yourselves achieve their business goals and objectives. I believe the slide that is coming up by the director, this slide, which is this slide, which mentions, I think it demonstrates and it mentions, it's not a function of if a security incident or security breach will occur. It is more of a function of when possibly a security incident or security breach will occur. And I just want to confirm that the slide is up. Is that correct?
That is correct, Mark. You're welcome to keep going.
Okay, thank you. We're going to go to the next slide. The next slide discusses an ounce of prevention is worth a pound of cure. And I think everyone understands sort of the compliance aspects that come with a security incident or security breach. And I don't think we want to rely on the adage of hindsight is 20/20. I think we have found, in light of the Equifax breach or the ransomware attacks, there's enough case studies for executives and business people to be able to sort of establish a compliance and an awareness program. And so that's what we're going to try to do today, and really sort of look at some data that we're aware of recently to sort of get behind the numbers. And today, as we were preparing, I talked to a few former colleagues that are in sort of the enforcement area, and they said, look, Greider, what I would have companies and executives focus on is control what you can control and plan for what you can't control. So we're going to go to the next slide and look at incident patterns. As you recognize from the numbers, a majority of these incidents happen by outsiders. But there is a significant number, to the point of 25%, that actually happens and are due to internal actors. And so going back to our adage about controlling what you can control, training and having security officers doing training and being able to evaluate and have a strong internal security system allows companies and leaders in those companies to be able to root out potential internal actors. The other issue that I want to bring to people's attention that this slide brings up is the types of groups. It's almost over 50% now that groups that are involved in incidents, security incidents, or cyber security breaches are actually involved or organized criminal groups. And that is why here in Washington, D.C. and across the country, we're going to talk a little bit more about this, of the importance of partnering before the fact with your local and federal law enforcement. We're looking at breach patterns. Go ahead.
As to incident patterns, primarily the insiders are people who are on their way out of an entity. I guess that's obvious, but keeping closer security of people as they're leaving is an important part of preparation, and making sure that all passwords are eliminated in a timely manner.
Thank you, Jeff. In terms of breach patterns, we're looking at some of the percentages of how these breaches have occurred, and sort of the one point that I'd like to bring to people's attention is really sort of the motive. And over time, I think law enforcement as well as in-house counsel, as well as law firms, have realized that the motives of perpetrators trying to breach systems has now moved more to a financial motive as opposed to just more of a disruptive motive. And I think that's critically important, and I think law enforcement is aware of that it's no longer just someone sitting in their basement attempting to just cause a disruption. Now you're dealing with enterprises that are actually financially motivated. So I think in understanding that motive, it does cause companies and executives to realize that we really need to pay serious attention to the people that are trying to steal company secrets or have financial motives.
As to the 27% of the breaches that are discovered by third parties, the vast majority of those are credit card companies or processors who have more sophisticated data analytics and usually identify the person who has the weakness before they discover their own weakness.
The next slide, we talk about just generally breach patterns inside of the industry. And I think this slide indicates the ability that you can see there's a small variance between the types of victims, whether it be financial organizations, healthcare, and even the public sector. And where some organizations may have sort of the financial means to recover from this, as you can see, the public sector, the variance between healthcare and the public sector is very minimal, but the cost across the different sectors could be the same, which could actually impact a specific company differently.
And certainly the different industry breaches cost different amounts. Primarily, breaches within the healthcare industry dealing with personal health information are much more costly than other types of breaches. So companies that either have, if they have a self-insured plan or for some other reason have personal health information or PHI, those companies need to be more vigilant.
The next slide, data breach tactics. I think this goes back to the idea and the notion that we want to be in a posture that we're controlling what we can control and planning for what we can't control. As you look at the data breach tactics, 81% are due to stolen or weak passwords. So this goes back to the ability to have a plan in place, having trained employees, and being prepared and having employees and having a playbook in place so when something does happen, you already have certain security systems that are ready to protect you from potential breach and breach response patterns.
As to the social attacks, primarily those are phishing attacks. They range in level of sophistication, but especially in the early part of the year before tax returns are filed, what we'll see are many cases of an email coming in purportedly from a CEO or top executive to someone in the payroll department, usually based on research from Facebook or LinkedIn where they have some of the personal details of these people, and it's a request to send the W-2 information that actually goes to an outsider, of course, and then oftentimes within hours, false tax returns, fraudulent tax returns are filed. And this is Jeff Jensen. I'm going to now talk about the 10 key components of a breach response, and I'd like people to I won't go through each one of these on this slide because I'm going to go through them individually, but with respect to this slide, we handle, I handle approximately one breach per month, and our firm handles many more than that. But these are the 10 areas, the 10 activity channels that we follow during a breach. And of course, the response plan needs to cover each one of these. Unfortunately, they're not sequential. They don't necessarily happen in this order, and they are all interrelated. But it's just important to keep all of these things in mind. In addition, what's important in a breach response is keeping a log of all of the activity, because eventually, most likely, if the breach is disclosed, there will be class action lawsuits filed, and what happened when will become very important. And it's important to document that at the time so you're not trying to do it after the fact. Also, each of these activity channels needs a team set up, and that needs to be set up in advance with notification trees so that you're not trying to do this in crisis mode. And also, you want to set it up in advance and have vendors providing all these services or internal people assigned to provide all these services, because you don't want to be negotiating with vendors while you're in crisis mode. They may not be available or they may be more expensive, so it needs to be set up in advance. So now I'm going to quickly walk through some of the issues that occur in each of these 10 activity channels. So the first one, security. And this is typically the IT department that will find out about a breach first, and they are trying to harden the system. It's not a one-time thing. It's a constant pattern of having to patch networks daily, as most companies will receive thousands of breach attempts during a single business day. Be aware that the first thing that hackers do is they go in and they create a covert channel. They set up their second entry. The first thing they do is to set up the second entry, usually by establishing a Trojan horse. Then the next thing they do is delete all traces of their initial intrusion. For example, the system logs. So the problem we run into frequently with IT security people handling forensics and the initial response is that they don't do this on a day-to-day basis, and they're not it's sort of the difference between doing surgery and doing an autopsy. They're just different skill sets, and if mistakes are made up front, then it can very dramatically reduce the ability to narrow the universe of data that was accessed or exfiltrated in a breach. So most companies don't have the skill set necessary. Some do, to handle a breach response, and rather they just go to their IT department, but that's an important decision. Next, we worry about legal. First of all, you would like to have everything covered under either the attorney-client privilege or the work product doctrine. Obviously, these privileges are not retroactive. So if attorneys are not involved up front, It makes it very difficult, and in fact impossible, to claim that a privilege existed. And you may ask, why do you care? Well, if you're not going to have to disclose this breach, it won't be an issue. If you do have to disclose it, you're going to have to disclose it anyway. Well, what we find is in the class action litigation, oftentimes early in a breach, people will write emails that have dangerous speculation or overly dramatic email that then can become extremely costly later. So the privileges that apply are the same as any other internal investigation. I would direct people to a case if they're interested in looking, which is called Kellogg, Brown, and Root. It's a D.C. Circuit case. It's also called Barco. It runs through each of these privileges and how they apply in an internal investigation. That case, it was very complicated, went up to the Court of Appeals twice, but I'll get to the salient factors, which are the question was whether non-attorneys doing an investigation on behalf of attorneys under the direction of attorneys would be privileged, and eventually it was determined that that is okay so long as everything is well documented. There's not over-documentation of privilege and not under-documentation of privilege. It has to be accurate. The second issue was whether the primary purpose of the investigation was in anticipation of litigation. And most companies have a compliance program that requires them to do an investigation, or they're in a regulated industry that requires them to do an investigation. So the court initially found that the primary purpose was to comply with those obligations as opposed to being in anticipation of litigation. Also, whether or not proper upjohn warnings were given, whether the information was later waived, and whether inside or outside counsel was being used. The result of all of those opinions, again, is that non-attorneys can do the investigation so long as they're acting under the direction of attorneys. It's okay if there's a blended purpose. Upjohn warnings need to be given properly. You need to make sure that the information is protected and the privilege is not waived. And finally, it does not matter whether inside counsel or outside counsel is the one directing the investigation. But it's important to make sure that all of the third parties you might use, such as forensic people and people doing public relations, are acting under the direction of counsel, and that is well documented so the privilege is not blown. Next, we talk about forensics. Again, it's a different skill set than IT people. It also is beneficial later when the class action suit comes because they have an appearance of more objectivity, which is valuable in front of juries. It's easier to maintain the privilege when everything's being done by a third party because all of the communications are privileged and you don't get sloppiness within a company that oftentimes happens. And in some breaches, it's required that you use third-party forensics. Next, one of the most complicated questions is whether or not you go to law enforcement, and if so, when do you go? So there are a couple of threshold questions you need to ask. First of all, is it a crime? If somebody just lost data, lost a hard drive, lost a disk, a laptop, well, that's not a crime. There's no sense going to law enforcement. The second question is whether you're going to have a disclosure obligation anyway. If so, then you might as well disclose it to law enforcement quickly. And this is a difficult challenge. And also it's difficult to find the right person to conduct the investigation. Each United States Attorney's Office has a person that's called a CHIP prosecutor, a computer hacking and intellectual property prosecutor. I would suggest you develop a relationship with that person. And then whenever there's a breach, wherever it is in the country, you can call your local CHIP prosecutor and ask that person for the contact in whatever venue you need. That way you have a warmed-up call, and it's much more effective. They know which agents are busy and which ones aren't, and which ones are good and which ones are not good. So it's important to develop a relationship with that person now. Also, you can maintain secrecy during an investigation. If you have a good relationship with the prosecutor, you can ask them to issue a grand jury subpoena. You can later engage in protective orders and protect the fact that you are a victim of an investigation if it was one that you did not need to disclose anyway. That lasts up until the point of a trial. If there is a trial, then the identity of the victim will be revealed. Also, when to call law enforcement, they measure that in terms of hours and days if you delayed to calling them as opposed to weeks or months. So typically what we will do is a soft call up front just so that we're on record and let them know that we don't know the extent of the problem yet, but we're working on it. And that way they're much more likely to be cooperative later. It's also important to call in ransomware situations when companies have the difficult decision of whether or not to pay ransom in a ransomware attack. It's much safer to let law enforcement know what you're doing in advance, and they will let you pay the ransom if that's what you choose to do. And then the public relations implications are important. You want them to you want them to say that you've assisted in the investigation or cooperated in the investigation when they eventually do a press release if your name is revealed. Hopefully you can keep your name out of the indictment if you have a good relationship with them up front and you're cooperating up front, and you can keep your name out of public disclosures. There are a whole host of regulators that get involved in breach response cases. The FTC, the Federal Trade Commission, gets involved. Typically, to date, they've been more concerned about the accuracy of disclosures than other issues. Health and Human Services, Office of Civil Rights gets involved with personal health information. And then 48 attorneys general have different, or 48 states have different statutory regimes with respect to personally identifiable information. And it's defined differently in each state, but normally that is a name or a portion of the name combined with some unique identifying number, such as a social security number or a date of birth. Other agencies that could get involved, you may end up dealing with the Department of Education if you have student records under FERPA, the Family Educational Rights and Privacy Act. It can require notifications. Also, with respect to false fraudulent tax returns, obviously you need to notify the IRS as quickly as possible so they can try to protect those accounts before fraudulent returns are filed. Next consideration we always keep in mind is insurance coverage. It's difficult to get cyber insurance. It's getting more expensive. There are more caps. They oftentimes have panel providers that you have to use their attorneys. And there are always questions about what losses are covered. Is it just the hardening of the system? Is it identity theft protection for victims, the class action lawsuit losses, lost business, reputational damage? And then there are always applicable coverage caps. And another question is what types of breaches are covered. So these policies need to be evaluated extensively in advance. And certainly you need to know when the timing of notifications is required, and you need to be mindful of the attorney-client privilege as you're doing that. Public relations is the next issue. First of all, you would like to have a plan set in advance. Assume you're going to be hacked. Develop your public relations plan now. You might as well write the press release now, frequently asked questions now, and you can tweak them later, but there's no reason to wait on doing that. You need a communications plan, and you also need a leak plan in case the information gets out about an intrusion that has not yet become public. And hopefully you have a consistent message over time and avoid a situation where you're disclosing a certain number of victims, then later you come out and disclose a much larger number of victims. And that's always in tension with the forensics people, because the forensics takes a long time, always longer than we would hope. And it's difficult to balance the PR against the forensics people. Certain stakeholders you need to be mindful of, obviously the customers, the employees, the shareholders. If you're a publicly traded company, you could have an 8K obligation to disclose a current event. If it's a breach that affects the controls over financial reporting, you could end up with Sarbanes-Oxley reporting requirements. And then finally, if there's a contingent liability under accounting standards codification 450 is the rule, can require disclosure of contingent liabilities. The last one, business associates and contractual partners, is very important. Oftentimes after a breach, people do not know what obligations they have to disclose to their business partners under business associate agreements, and that's all work that can be done in advance. So when a breach happens, you know exactly who you have to notify and when you have to notify those people. Personnel management obviously becomes important. I'm sorry, the wrong slide is up. I'll just talk through personnel management. It becomes important. Usually there's some at least training that needs to be required. Typically it's patching things in a more timely manner. If it's an internal actor, obviously there's discipline and potentially litigation that can result. But the trick is you have to take affirmative action for people that are responsible for these breaches. That's an important part of defending a class action lawsuit. And then the notifications that are required. It depends on what type of information is involved. As I discussed earlier, if it's PHI, protected health information, the notification needs to go to the HHS, Office of Civil Rights. If it's 500 or more people involved in the hack, then that has to be done within 60 days of the point of discovery. If it's fewer than 500 people, then the disclosure has to be within 60 days of the end of the calendar year. So a slightly lesser requirement if it's fewer than 500 people. If it's personally identifiable information, which I briefly explained there earlier, but it's difficult to explain because it's defined differently in the 48 states, then there are all different types of triggers and all different types of windows during which the reporting must be done. What we do is just keep a running list of all of the state requirements so that it's current. If you're trying to do this research immediately after a breach in crisis mode, it's difficult to get the research correct. And in both the PHI disclosures and most of the PII disclosures, the personally identifiable information, have law enforcement exceptions. So it's another good reason to work with law enforcement early on if a crime is involved and if you think disclosure will be an obligation anyway. That can be very helpful because if law enforcement requests that you not disclose the existence of a breach, you're allowed to use that. You get more time to conduct the forensic exam and find out exactly what the problem is before you have to make a disclosure. And then finally, payment card industry. If you have credit card information, it's a complete mess. There are data security standards that apply per most of the merchant processing agreements, or per all of them actually. And then those are typically about 10 pages long. They incorporate by reference the brand rules of Visa, MasterCard, et cetera. Those can be around 1,000 pages long, and it's very difficult in crisis mode to try to conduct all of that research in a hurry. And at that point, I'll turn it over to Mindy.
Great, and I'll add to that on the payment card information topic. A lot of companies aren't really aware of how the process works out, but if you process or store any credit card information, payment card information, and it is compromised, one of the first notification requirements is to the card brands themselves, and the card brands will then require you to get an outside forensic investigator to come in and do a PCI compliance report, which even though you might have that conducted with your attorney, it's not going to be privileged because it does have to go to them, and that can really determine your liability in that instance because, as we all know, when we've had our credit cards stolen, you just call your bank and say, hey, I've got some fraudulent charges. The bank will remove the charge and issue a new card. Well, those costs are offset to the merchants who are breached, and under the contracts that companies have with these brands, they will do various investigations and may levy very, very large penalties on companies in the event of a breach. So it's really helpful to be sure of what your potential liability is, with your credit card brand and under the different policies that apply to that. Because as Jeff mentioned, they can be very complicated, but they also tend to frequently change. So it's very important to be aware of those things. So moving on to the response plan, we've talked about these different channels and things that apply and have given it a broad brush. Hopefully you have seen that these different channels all work together, and in the event of a breach, they're all pretty emergent all at once. So in order to be able to put together a plan and put your company in the best position, you need to think about all of these different channels and determine what is your company's biggest risk. And unfortunately, it's different for every company. It really depends on your business model, on how many vendors or other people are able to access your system. Today, with more connectivity, everything going to the cloud, and many software as a service and smart products, we're more and more connected than ever, which is great for efficiency and customer satisfaction. but can cause a lot more potential risk for you. So every company's different breach response plan is going to be different, but again, they all share many of the same themes. One of the most important strategies is to first identify who your team is. And while that, of course, includes your internal team, which should have somebody from the C-suite, if possible, that can quickly make decisions, you also should try to have your legal team, law enforcement, forensic team, PR team, and all these different potential partners lined up. And the reason for that is, as Jeff mentioned, it can be very, very difficult to try to negotiate different services while you're in the middle of a crisis. It's also really important for your team to understand what some of the potential costs involved are. So, for example, it has become very common in the event of a breach including Social Security numbers or credit cards to have credit monitoring services. Well, credit monitoring services can be extremely expensive. It can be up to $300 per person you're providing it to. So if you've got a large number of people affected, it can be a substantial expense. So that's an area of an example where it's a really good idea to try to get some information about that before a breach occurs and have a relationship with a provider with some set terms. Same thing with call.
I'll interrupt Mindy there to take a question. The question reads, we just went through several vendor demonstrations as a part of our demonstrations script included PCI compliance. Each and every vendor deferred to the bank we use to process our credit card payments. Please confirm, is it the higher education institution that needs to be PCI compliant, or does the bank hold the responsibility, or both? The short answer is both. And when litigation ensues later, there certainly can be finger pointing. We see that frequently, but both have an independent obligation, and it is who acted negligently that will end up bearing the cost. And there certainly will be litigation costs, but the short answer is both.
Yeah, and to add to that, it also depends on what the contracts are between the different parties, which we'll talk about that a little bit more later, but sometimes, well, very frequently, you'll see contracts trying to shift all the liability to one party. So that's another important aspect of all of the data breach planning, is to make sure you know what your different contracts say and who bears liability. That also plays into the insurance piece as well. Back to managing your team. Not every forensic team out there is created equally. Some are much better than others, and it can be really great to create a relationship with a forensic team before you have any problems. Oftentimes they'll come in to provide education for you anyway, or maybe do an audit of your system, which can be very helpful. Same with law enforcement. As Jeff mentioned, many law enforcement teams are very, very proactive in this area. I'm in Madison, Wisconsin, and our active chapter is the Milwaukee-based FBI group, and they are very, very active in getting out into the community, going to different companies to talk about the different risks out there, and there are a lot of opportunities for your company to get to know these different players that are involved. So once you have your team in place.
That gets to another question we have, which agency to call. What I talked about earlier was calling the U.S. Attorney's Office. That holds true unless, like in Milwaukee, they have an established group and you're familiar with that group. Oftentimes people call the local law enforcement, and typically they're busy handling other things and are not necessarily as skilled in handling breach responses. And then you have the FBI, the Secret Service, and the postal inspectors, and a bunch of other agencies that handle breach response. But usually if you don't have an established group, if you go to the U.S. Attorney's Office first, they will know where to send you depending on the facts of a case.
Jeff, if I can chime in addition, here in D.C., there's a unit called the Computer Crime and Intellectual Property Section. They've actually issued some documents on sort of victim response and reporting of cyber incidents, and they have sort of an industry phone number that can actually help you also get to the U.S. Attorney's Office. So But go ahead, Mindy.
Thanks. So in getting back to response planning, once you have your team in place, one of the most important things to do is to identify what sensitive information your company holds. Maybe you're holding credit card information. Maybe you have sensitive research and intellectual property. If you're a financial institution or a healthcare institution, you're going to have sensitive information there. And maybe not. I mean, even if you're a retailer and you're selling products or services, you're going to have information on who your customers are, where they're located, and what they're purchasing, which may not trigger a reporting breach, but if somebody steals, for example, all of your customers' names and information on what they purchased or what services they purchased, you could run into some issues there. So a good starting point to understand your risk profile is to say, what kind of information and data are we handling? And when you look at that, you'll want to look at more than the information your company is actively managing, but also what other systems are you getting services or products through from vendors, for example, so you can understand. Once you realize what information you have, it's a good idea to look at your various contracts to see what liability you have and what liability has been perhaps shifted to another entity. Also ensure that you have the appropriate insurance coverage. And as Jeff had mentioned, it's a really good idea to pre-draft press releases, notification letters, and call center scripts. While you're going to end up changing these based on the circumstances of the particular incident or breach, if you know what information that you have that's most vulnerable, you're going to be able to come up with something so you're not starting from scratch. That being said, when you do have your communications plan, it's really important to make sure that you're working with a PR or communications team that is skilled in crisis communication and can help you walk through the timing on giving notification to different people. When a security incident first happens, your response team is going to be all over it, but unless it's ransomware or something that's on every screen in your company, you're not going to want mass chaos to get out by informing every single employee or stakeholder that this has happened. It's really going to go in phases as to when different people are notified and how they're notified. You're going to want to make sure that your releases and notification letters are very, very consistent, as Jeff mentioned earlier, but you're going to need to make sure that you have all of that in place. It's also a really good idea to make sure that you have your key insurance contracts and key contractual agreements readily available. Many times if you are working with say a third-party website provider or a cloud hosting provider, and there's some problem and you find out the breach came through that system, you're going to want to be able to quickly look at it and see what your rights are, what your obligations are, and what you need to do. When you do have your breach response in place and you can put together a checklist, the key is not to stop there. You can't just have this plan and put it in a cupboard somewhere. You need to make sure that it's a document that's being reviewed and updated. You're going to want to make sure that you do a dry run, do a tabletop crisis simulation, bring your group together and run through a mock breach. It may even be good to do it with, an outside forensic investigator when you're doing an audit, have your legal team there, but make sure you're running through it and you see what really happens when you're walking through that. If you've gone through it a couple of times in that manner, where it's less of an actual chaotic crisis, when it does happen, you're going to be more prepared to call the right people, engage the right systems, and take the right steps. As we probably saw with the Equifax breach, they're already getting widely criticized based on some actions that have been taken. And ideally, if you as a company understand what mistakes have been made before you start all your press releases, it puts you in a better situation. So having the response plan in place is great, but making sure that you're running through it and updating it is also critically important. Now, when you do your response plan, it's also good to remember that you don't need to start from scratch. Most companies already have existing policies and procedures in place. So go out and pull through what those are and begin working on them and updating from there. If you can't find your existing policies, maybe there's, other issues that your company needs to take in making sure that more people are aware of the different policies and procedures in the event of a breach response plan. And then, another very important issue to look at when you're going through your breach response plan is breach response planning shouldn't be limited to simply writing a plan on what to do with a breach. It should be more of an ongoing process within your company. And the place that it needs to really start is in your IT review, making sure that your information technology team is aware of current trends in different hacking situations or phishing situations or other security incidents. There really is no silver bullet, although many IT security companies will try to sell you a product saying, if you get this, you're going to be bulletproof. That simply doesn't exist. And in fact, if you look at the trends, the Equifax breach was the cause of Equifax was using some open source software in its system that had a vulnerability. They learned of the vulnerability. A patch came out for it the exact same day, but it took them 2 months to actually apply the patch and to update their system. Similarly with the big...
A good way of testing to make sure, a good way of keeping your breach response plan current is, one, the obvious is doing penetration testing and having outsiders come in and do penetration testing. Another one is to hold a tabletop exercise where you just go through a mock breach, and almost inevitably there are improvements to a breach response plan that result from a tabletop exercise.
Correct, and that's the same with if you get, external auditing done. That's always very helpful as well. But the main point that I wanted to make with it is many of the big breaches that you see out there could have been prevented by simply keeping systems up to date and making sure that patches were applied. The WannaCry ransomware attack that took place a couple of months ago affected companies in 150 different countries. It was a massive attack, and it was all related to a Windows update. And if your company had promptly installed the update to the software, you were immune from that attack. If you waited too long, you were vulnerable to the attack. So it can't be underscored how important it is that IT is constantly updating software and security measures, making sure that encryption technology is up to date, and doing all of the testing necessary. Another very important area that I actually work in a fair bit is not only reviewing your contracts with your vendors and suppliers when you are in the throes of a breach or in data breach planning. It's very important to be thinking of these issues as you're entering into relationships with other companies and independent contractors. Very often, data privacy and security issues are overlooked when companies are contracting for different products or services. Yet, at the same time, outside vendors cause most breaches that you see out there. I mean, sometimes you do get the emails where somebody's posing as a CEO, as Jeff and Mark mentioned earlier, but oftentimes too, when you're talking about third-party hackers, they can get into your system where you're providing access to a third party. And if you're not dealing with that in your contracts as you're negotiating them, you can find later that vendors often disclaim all liability for data privacy and security. They'll tell you that the software as a service that they're providing to you or the cloud hosting services they're providing to you are entirely as is. And unfortunately, sometimes you as a company may have to be stuck with that. Some of the biggest cloud providers will not negotiate that, but it's good to know if that's the position you're in, and certainly if you have the ability to to negotiate some of these provisions, it's an important time to do that. And then also filling in where you do see it, you have some liability with the insurance coverage that we have talked about. So with saying all of that, I'll pause and see if anybody has any questions at this point.
We have a question here, Mindy. Why would we disclose to law enforcement if we have no obligation to do so? Which is a great question, by the way.
Yeah.
So first, it's very hard to know what the extent of a breach when you first start out. It's oftentimes that there's a covert channel set up and you're trying to prove a negative. You also have the potential of internal whistleblowers who may reveal the existence of a breach. So you may be in a situation where you decide not to disclose up front, and then if later on it gets worse, you have to disclose based on what the forensic review shows, and then you will be in the very difficult position of trying to explain to law enforcement why you didn't disclose earlier. And that can cause problems with respect to the secrecy I talked about with the friendly grand jury subpoena or with the protection order if your relationships are difficult with law enforcement because they were tardy. It also you can take a PR hit for that, for not disclosing up front. It's better if you have to do notifications to be able to say that you disclosed it to law enforcement and you're working with them. So it sort of changes what disclosure you will make eventually. But typically it's better to, as I said, to do that soft call to law enforcement and let them know that you're aware of a problem and you're still looking into it, and you'll let them know what you find. And
Jeff,
another question. Yeah, go ahead. I'm sorry.
Yeah, one other thing, in the event that you do disclose, especially in the federal level, one phrase that's been sort of used, whether it be with the FBI or the Department of Justice, is their goal is not to re-victimize the victim. And so that's something that as I've worked with different clients and companies that have been victims, and they chose not to disclose, but later a third party, they found out there were multiple victims, and later they had to disclose information. When you're dealing with the government, they're essentially on the federal level, they have the understanding that if you're a victim, their goal is not to re-victimize you by having to, spend an extraordinary amount of going back and doing sort of the due diligence. So it's as Jeff was suggesting, that relationship, it's important to have that relationship up front to sort of manage on the back end.
Yeah, and I would agree that it can really help. It will really have a ripple effect on whether there are class action lawsuits or attorney general investigations or Federal Trade Commission investigations. Early on, when data breaches started occurring, companies were finding themselves holding liability, and that landscape has really started to shift as regulators and others, judges, have begun to realize that, companies can't 100% prevent cyber attacks. Going back to what Mark said, control what you can control and plan what you can't, people understand that. And if you can present your company in the event of a data breach saying, listen, we did everything that we possibly could to try to protect ourselves and to protect our customers and our stakeholders, the better you can be. And that's going to be having these plans in place, contacting law enforcement, and really presenting yourself in a transparent way to your consumers when you need to, saying, look, we were trying to protect you, we were trying to protect ourselves, and being able to say, one of the first things we did was turn to law enforcement for help because we were victims here. That can go a long way.
In another way that it can benefit victim entities, which is more subtle, but it's important, prosecutors, and when we used to prosecute these cases, have different tools they can use. There are different statutes they can use. For example, they can charge something under the statute is Title 18, Section 1030, but it's essentially unauthorized access into a computer system. That's easier to prove, and it's less painful for the victim than if they use a trade secret statute, which is Title 18, Section 1832, which really puts the company's protections over their trade secrets at issue. So if you're in that worst case scenario where it's public, you're going to trial, and you're going to be identified, the last thing you want to do is have any weaknesses, any internal weaknesses be subject to cross-examination on Front Street. That can be a difficult situation for a victim entity. And we have another question that just came in. When you speak of notifying law enforcement, who and through what channels are you specifically referring? There are many different ways to report to law enforcement, so there is no one channel. The FBI runs, and some other agencies run, what's called IC3. It's the Internet Crime Complaint Center, and you can do it online. I think that's probably less effective, almost always, than having an established relationship with an agent that works on those cases. So in particular, you want to develop a relationship with the assistant U.S. attorney who handles computer crime cases. And if you're in emergency mode and you haven't done that already, you can just call the U.S. attorney's office and ask for the computer crimes prosecutor, and they will put you in touch with that person. You can also go to the FBI or the Secret Service or the Postal Inspection Service. And you can go to local law enforcement, but we found that to be typically less effective. And of those various channels, the most effective is usually to go to the U.S. attorney's office, unless you already have an established relationship with an agent. And then we have another question here. Who do you use for forensics or public relations? Well, probably best not to say who we use at the risk of offending others, but I'd say at the conclusion of this, if anybody would like to contact any of the three of us, we'd be happy to talk you through who we use and why. It's based on experience in doing breach after breach, and we just work with the forensics teams and the PR firms that have been most effective over time.
Yeah, and the other piece of advice that I would share for any company that's either creating a breach response plan or updating the breach response plan, one other critical piece of it is to make sure that you're funding it as well. Unfortunately, breaches are very expensive, and they're only getting more and more expensive every year. The amount a breach is going to cost you is going to depend on how many records were stolen, what was stolen, and they're all a little bit different. But many times companies really underestimate the cost. I've read about breaches where it costs the company over $400,000 just to send out the notification letters with the postage. Credit reporting monitoring services are often provided to customers in the event of breaches. As I mentioned earlier, those can be very, very expensive. So it is a very good idea to invest and put aside funding in the event of a breach so that the company doesn't find itself scrambling and facing, a multi-million-dollar breach response.
And then,
so with that, do we have any more questions?
No more questions. I guess I'd just add one final point is that once you have a breach plan established, as Mindy has mentioned and talked about the various elements of it, it's extraordinarily important that in the event of a breach, you actually follow your breach plan. I know that's stating the obvious, but that is often what causes problems later in litigation in the class action lawsuits if there's a breach response plan in place and a company did not follow their own plan.
Absolutely. Thank you, Jeff. Thank you, Mark. And thank you, everyone, for joining us for our program today. We hope the information provided was helpful for you and your organization. If you have not already completed our short survey, please click on the survey icon at the bottom of your screen to complete it. Your feedback assists us in providing quality future programs. And as a reminder, This program is approved for CLE in Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. It is pending in Wisconsin. We expect that to be approved shortly. A recording of the webcast will be available tomorrow for watching and sharing. Once it's available, we'll send you a link with the recording along with the certificate of attendance. This concludes our webcast, and thank you very much for attending.